Hi friends, welcome. So we are going to discuss the answers for the Polity test that was conducted today. So as a practice, we will try and ensure that the respective faculty discuss the papers or someone who is an expert in that area who will discuss these answers. The aim of this test discussion is to familiarize you not with the answers per se, see, because this answer key is going to be circulated to you and all of you are going to read it and revise it. And you will be able to understand why a particular answer is chosen by just reading the explanation. So the purpose of this test discussion is to just highlight certain important points from the subject, but more importantly to let you understand that in UPSC exam you can intelligently eliminate options based on your known statements. So it is not necessary that you should exactly know whether all the three statements given are correct or not. Even if you know two of those statements, and in some rare cases by just knowing one correct statement you will be able to arrive at the right answer. So that is the purpose why this test discussion is going to happen in that manner. And another point for all the batch candidates, there have been some questions which have been asked about parliamentary committees. Don't worry, there is going to be a separate class which I will be handling on parliamentary committees subsequently when we cover the political system and the rules of Lok Sabha and Rajya Sabha. However, we have briefly discussed about these committees on and off when we have been discussing other aspects in the class, and hence those questions have also been asked as part of this test. But you don't have to worry that that has not been covered in the class. That will anyways be covered in the class as well separately, though you must have a working knowledge about those committees based on current affairs and based on other aspects, and that is why that is also part of this test. So let's go straight away. I will be discussing all the polity related questions, and towards the end the current affairs questions and the map questions are pretty straightforward, so you will be able to understand them based on the explanation that is given in the answer key. So let's start. First question, the expenditure charged on the Consolidated Fund of India can be discussed and voted by the Lok Sabha, part of an appropriation bill. So here you know for sure that the definition, the significance of an expenditure charged on the Consolidated Fund of India is that it can be discussed but it cannot be voted even in the Lok Sabha. So automatically you eliminate option A and you eliminate option C, because both of them have first statement also as a correct statement. So now you are left with only a 50-50 choice between option B and option D, but obviously appropriation bill, as we have discussed in the class, consists of expenditure charged and also the demand for grants which is voted by the Lok Sabha. So the correct answer is B. So that is, all the correct answers are marked in red, so you will be able to view them when you are viewing it. So which of the following statement are correct about cabinet committees? They are extra constitutional in nature and nowhere mentioned in the constitution. So we have discussed the legislature in detail in the class. The cabinet committees, as I had mentioned to you about the control and various other things, and you have read in current affairs also, the cabinet committees are part of the rules of Lok Sabha. So automatically the first statement is correct. They are not mentioned in the constitution, you will be able to immediately determine. So then again this becomes a 50-50 question. So automatically you are eliminating option B and you are eliminating option D. So the choice is between A and C, but the second statement is not right, because the cabinet committee on security, which is a very important committee, will obviously be headed only by the Prime Minister. So you should be aware of cabinet committees, but it is also a bit of common sense that you can apply here. It is only the cabinet committee on parliamentary affairs which is headed by the Home Minister, but all other cabinet committees are headed by the Prime Minister. So the answer is A, which is 1 only. The representatives to Rajya Sabha from union territories having legislative assemblies. So it's a straightforward giveaway question. There are only two union territories which have a legislative assembly. One is Delhi, the other is Pondicherry. You know that Rajya Sabha members are elected by the states. So obviously for these union territories having a legislative assembly also, they are going to be elected by the members of the legislative assembly. So it's a very straightforward answer, which is B, because nomination happens only at the central level by the central government. 12 members are nominated, but from the states and these two union territories having legislative assembly, It is the MLAs, elected MLAs of these states and elected MLAs of this Legislative Assembly of Delhi and Pondicherry who elect the Rajya Sabha members. So the answer is B. Consider the following statements about MPLAD scheme. Again, this has been covered in your current affairs class. We will be covering it as part of the political system again, but it has already been covered in your current affairs class, and that is why this question has been asked. So here, if you look at it, the concerned MP can both recommend and execute the proposed project. So the moment you know that that first statement is wrong, then you automatically eliminate option A. The concerned MP is responsible for maintaining figures of expenditure for the concerned projects. Again, it is only the collector, the district collector, who is responsible for that. So you eliminate the other two choices. And finally, the third, nominated MPs can be assigned funds under the scheme. This you should be aware of. The nominated MPs can select any district from any state in the country. So the option is B, 3 only. Who among the following can authorize the Parliament to create new All India services? Now this is under the powers of the special powers of the Rajya Sabha. When we had discussed under the legislature, this will again be discussed in center-state relations, but when we had discussed about the special powers of the Rajya Sabha as part of the legislature, we had said creation of All India services and creating, making the Parliament legislate on any matter in the state list if it is of national importance. These are two powers which are specifically given only to the Council of States or Rajya Sabha. So obviously the answer is C, Council of States. Consider the following statements. The chairman of Rajya Sabha can be removed from his office only if he is removed from the office of vice president. It's a very straightforward statement. We know that the vice president is the ex officio chairman of Rajya Sabha. So the first statement is correct. The moment you decide that one statement is correct, you are automatically making it a 50-50 question. So please be careful about these simple techniques that you should definitely employ. Not go and get confused between all the 4 options in the test and waste your time. You know the first statement is right. So the choice is between A and C. And the second statement is again a straightforward statement. The chairman of Rajya Sabha is called an ex officio chairman because he is not a member of the house, whereas the speaker is not called an ex officio speaker because he is a member of the house. So the second statement, unlike the speaker, the chairman of Rajya Sabha is not a member, is also right. So the answer is both 1 and 2. In which of the following cases the Rajya Sabha has an equal status with the Lok Sabha? Introduction of money bill. We have seen the most important two procedural requirements for a money bill is 1, it can be introduced only in the Lok Sabha. 2, it can be introduced only with the recommendation of the President. So the moment you recollect this, then you know that Lok Sabha and Rajya Sabha do not have an equal power as far as money bill is concerned, because it can be introduced only in the Lok Sabha. When that is the case, automatically you are eliminating 2 choices. Look at option B, 1, 3 and 4. Look at option D, 1 and 4. So the moment you know that the first statement is wrong, you know that B and D are wrong. Then automatically it becomes a 50-50 question. Authorizing Parliament to create new All India services. Again, see, the syllabus here is limited. So there may be the same areas which may be asked in different types. But despite the UPSC preliminary exam being a full-fledged exam from all the areas, you will be able to get clues for the answers for some questions based on how you have solved the previous question. So in the previous question, you have picked up that Rajya Sabha has the exclusive power to create All India services. Now look at this question. The authorizing the Parliament to create a new All India service is given as an equal status for both Lok Sabha and Rajya Sabha. So automatically this also goes out of the window. So the correct answer is 3 only. So by just knowing that one statement is wrong out of the 4 statements, you have been able to eliminate 2 choices. So it becomes a 50-50 question. And on top of it, based on the answer for a previous question which you would be aware of, you will be automatically be able to eliminate the other choice, and so the correct answer is 3 only. So, friends, you should ensure that you internalize all these techniques. It's a continuous process, but we still have enough time. We are going to have almost 30 tests before your actual preliminary examination. So, please but take it seriously. And another word which I want to say to all the people who are watching this video, I saw people coming out of the hall at 4 o'clock today. The test started at 2:30. Please don't do that. Take every weekly test as the UPSC preliminary examination. Spend that exact 2 hours inside the hall. Only then you will be able to apply these elimination techniques. Even if you know one statement, you can reduce it to a 50-50. By just linking it to some other question, you will be able to arrive at the final answer. Otherwise, you may be wondering that, okay, I don't know the answer for this. Don't be in a hurry to solve the questions and get out. You should use the entire 2 hours fully. So, please have that in mind. Now, going to the next question. Which of the following situation warrant the calling of a joint sitting of both the houses by the President? It's a straightforward question. There are 3 situations when a joint sitting can be called. 2 of them are given here. So, the answer is both 1 and 2. So, I am not going further into detail in this. The explanation is given in the answer key. It's a straightforward question. There are 3 conditions. 2 of those conditions are mentioned here. So, the answer is both 1 and 2, which is C. In addition to the members of a house, who has the right to speak in both the houses? Union Minister is a straightforward answer, and you know that Cabinet Secretary cannot speak in the House. It's very logical. A bureaucrat, an IAS officer or an IPS officer, IAS officers are usually appointed as Cabinet Secretaries. So, bureaucrats don't go and speak inside the House. So, the moment you are aware of this, see, 1 is right. So, you know that the option is between A, C and D, but you know that 3 cannot be right because the Cabinet Secretary does not have the right to speak in. So, between A, C and D, it is only A which has both 1 and 2. So, the moment you know the first statement is right, you have eliminated one choice, which is 2 and 3 only. So, you have eliminated this. But the moment you know that the Cabinet Secretary will not be able to speak in the House, you are eliminating this as well, and so the answer is 1 and 2 only. Right. So, moving forward, the provisions of joint sitting is applicable to which of the following bills? Again, when you look at the question itself, immediately try and pick the wrong statement and see whether based on that you are able to eliminate the choices. Constitutional amendment bills. It has been clearly discussed in the class. You are all aware constitutional amendment is governed by Article 368, which is a separate provision. So, an ordinance cannot be brought for a constitutional amendment. So, 3 is not the right statement. So, automatically it gets reduced into a 50-50 choice. And then, as you are aware, it is only the money bill for which joint sitting provision is not applicable. The Constitution clearly says, Article 108, which has the provisions for joint sitting, says that this provision is not applicable to a money bill. Financial bills have certain requirements of being introduced only in the Lok Sabha or being introduced only with the recommendation of the President, which is category A. Category B requires recommendation of the President before consideration. All that is fine, but after that they are like any other ordinary bill. So, the answer is A, which is 1 and 2 only. So, the key here, I am not discussing the provisions, we have discussed that already in the class in detail. I am only telling you the techniques which you should follow in eliminating choices and making your job easier for selecting the right answer. The moment you know constitutional amendment bill cannot be passed through a joint sitting, you know that option C and D is not applicable. So, the correct answer is 1 and 2, right? So it is only money bill which is not subject to a joint sitting, and of course constitutional amendment bill. Consider the following statements regarding the parliamentary privileges available to the members. So this is again an example of a question where by just knowing one statement, you will not reduce it into 50-50, you will know the answer itself. They cannot be arrested during the session of parliament for both civil and criminal offences. We have discussed specifically that the parliamentary privileges of not being subject to arrest under the civil procedure code for 40 days before and after the house is in session is only applicable for civil matters. It is only the president and the governor who cannot be arrested even for criminal offences. But privileges of members is only for civil matters. The moment you know that the first statement is not correct. But look at the choices. There are 3 choices which have the first statement as a correct statement. So all these 3 choices are wrong. So you don't even have to read the second and third statement. I mean, don't do that. I am just telling you with certainty, you know, when you have shortage of time or something like that, please do read the statements once quickly. But technically speaking, you don't have to read the next 2 statements at all, because you know the first statement is wrong. 3 answers have the first statement as the right statement. So automatically the choice is only the one which does not have 1 as the correct statement. So you don't even have to worry. By eliminating one statement as a wrong statement, you have arrived at the right answer. So look out for these elimination process. That will ensure that you are not making a mistake. Over and above your knowledge, these techniques will also help you in arriving at, because sometimes you may get confused with certain ambiguous statements. They are not ambiguous per se, they are only based on either the constitution or either the rules of Lok Sabha or Rajya Sabha. But you may not be aware of it, but you don't have to worry that you are not aware of that statement, because the choices will ensure that you arrive at the right answer, right. So for example, the third statement here is the presiding officer of the house as the final authority in deciding the breach of privileges. You may be confused, oh, is it the presiding officer or could it be the parliamentary committee on privileges which will decide whether there is a breach or not? Is it referred by the presiding officer to that committee and only then it takes a decision? You may have that ambiguity, you may have that confusion in mind, but you don't have to worry about that confusion, because the only option which doesn't have the first statement as the right statement, which you know for sure is wrong, is option C. So it's a straightforward answer, right? So please have these points in mind in your future test if you have not already done them in this test. Which of the following does not find a mention in the constitution? So we have discussed, when we discussed the 10th schedule, that party whip is there, it is not as per the constitution but as per an act, statutory act, and as per convention. Leader of opposition is and leader of house is again based on the rules of Lok Sabha. So none of them are mentioned in the constitution. So the answer is D, which is 1, 2 and 3. With reference to the Indian Parliament, consider the following statements. A starred question requires an oral answer and hence supplementary questions can follow. This is a very, very straightforward point. We have discussed it under the legislative control. There are 2 types of questions, starred questions, unstarred questions, and there are also short notice questions. Now, but what is a starred question? It requires an oral answer by a minister. So you know the first statement is right, then you are reducing this into a 50-50 choice, right? So this cannot be the right answer, this cannot be the right answer, because you know the first statement is right. And which are the 2 choices which have the first statement as right? 1, A and C. An unstarred question requires a written answer, that also you know. So automatically you have arrived at the answer. So it doesn't matter whether you know whether the third statement is right or not, because you know the first statement is right. So the choice is only between A and C, and both of them don't have the third statement as the right answer. So the moment you know the second statement is also right, you have arrived at the answer, right. So keep this in mind. It is not necessary that you should know all the statements. I mean, that doesn't mean that you give up on your, or reduce your preparation. Please prepare all the areas thoroughly. But even after that, there may be some statements which you may not be fully confident about. But the way the UPSC gives the options, the moment you are sure about one statement, you can reduce it to 50-50. And if you are sure about two statements, you can definitely put the right answer. It is in very, very rare cases that you will still be confused between two options after knowing 2 out of 3 statements. So please have that in mind while eliminating your choices. The Parliament of India exercises control over the functions of the Council of Ministers. This is a straightforward question. It's a repetition of the 2017 question, but it's an important question, so we have asked it again as part of our test also. So all the 3, adjournment motion, questionnaire, supplementary question, are all used as tools of legislative control over the executive. So the answer is D, which is 1, 2 and 3. In a parliamentary democracy, the legislature exercises control over the executive. That is the nature of the parliamentary democracy, right? Executive and legislature being completely separate is a presidential form. In a parliamentary democracy, it is the legislature which controls the executive. The executive will never be able to control the legislature, right? So the legislature is always more powerful than the executive. In a presidential democracy, they are both, they have their both defined powers, but still laws have to be passed only by the legislature. So it's a straightforward question, and in fact, the 14th question, the previous question said, Parliament exercises control over the executive. In fact, the answer for this question is in the question, the previous question. You understand? The answer for the 15th question is actually the question which is asked in the 14th question. So please look out for such linkages between questions. As I told you, because it is a limited area, you may think that such linkages are coming. No. Even in UPSC, even now, it is a full syllabus that the UPSC asks questions in, but still you will be able to establish linkages between two questions. When I say that, the moment you know the answer or you know one statement in one question, you know that it will help you identify the answer in some other question. So please have that in mind, have those linkages, have those elimination techniques, all that in mind, and you should use your entire 2 hours to put all this into practice so that you get the maximum questions right. Yeah. So when an ordinary bill is referred to a joint sitting of both the houses of the parliament, it has to be passed by majority of both the houses present and voting, right? So it is not, so here if you look at option A, it is majority of total number of members of the house. So that is why this statement is wrong. You know that 2/3 majority is not applicable to a joint sitting. You know that special majority is not applicable to a joint sitting. So you will not be confused between C and D. But you may look, it may appear that both A and B is similar, but look out carefully in the question. Here it talks about majority of total number of members, and that majority is not mentioned anywhere except for presidential impeachment. So, and that too, that's a 2/3 of the total membership of the house. So majority of total members of the house is not a majority at all in the constitution for anything. So once you are aware of that, you will be able to easily identify the answer, which is option B, right? So answer is B. Consider the following statements about private member bills. Members of parliament who are not ministers are called private members. That's a pretty straightforward statement. So you know that that is a right statement. The moment you know that it's a right statement, this question becomes a 50-50. So the option is, the correct answer is either A or C. Private members can introduce a constitutional amendment bill. So there is nothing in the constitution which says that only ministers or government can introduce a constitutional amendment bill. A constitutional amendment bill can be introduced in either house of the parliament. We have seen the legislative procedure. Private member bills can also be introduced in either house of the parliament, but the leave of the house or the permission of the house has to be given. So constitutional amendment bill can also be introduced by private members. So the correct answer is C, right, which is both 1 and 2. The next question, for which of the following voting is held by a secret ballot in the parliament? Again, this is a classic example of a question where if you know one statement is incorrect, you arrive at the answer. Look at the first statement, election of members to the Rajya Sabha. Who elects the Rajya Sabha members? The elected MLAs of that particular state. So automatically, forget secret ballot or open ballot. The Rajya Sabha elections do not happen in the parliament, right? So the question is, which of the following voting is held by a secret ballot in the parliament? Whereas Rajya Sabha elections don't happen in the parliament at all. They happen in the legislative assemblies of those respective states whenever a vacancy arises. So you know the first statement is wrong. The moment you know the first statement is wrong, you have arrived at the right answer. So again, this is a classic example where you don't even have to read the other two statements, technically speaking. You know the first statement is wrong, 3 of the options have the first statement as the right statement. So the moment you know the first statement is wrong, you have arrived at the right answer. Clear? So please be clear about these techniques you will be able to get more answers right. Of course, knowledge is the base. Without knowledge, you will not, you cannot just apply techniques and clear the exam. Over and above the knowledge, such techniques will help you to be sure. You don't have to waste too much time wondering whether is there any resolution of the house which may be subject to secret ballot. Is there any instance where such a thing has happened? You don't have to worry about or confuse yourself with all those statements at all. You know the first statement is wrong. There are 3 options which have the first statement as right. So obviously, it is that option which does not have the first statement as right which is the correct answer. Right? So the answer is C, 3 only. Consider the following statement regarding duration of Lok Sabha. President can dissolve the Lok Sabha based on the advice of Council of Ministers at any time before the completion of 5 years. We know that is a correct statement. So again, by knowing that that statement is correct, you have reduced it into a 50-50 because these 2 statements are wrong. But the second statement, you will have to be careful about what is mentioned there. The term of the Lok Sabha can be extended indefinitely during the proclamation of emergency. It cannot be extended indefinitely at once. It can be extended only for a period of 1 year, as we had discussed during the duration of the houses. During the term, during the proclamation of emergency, when there is a proclamation of emergency, the Lok Sabha duration can be extended for 1 year at a time. So the second statement is wrong. The correct answer is A, which is 1 only. Consider the following statements. 4th schedule of the Constitution deals with allocation of seats in the Rajya Sabha. We have discussed that when we discussed the salient features and unitary features and federal features of our Constitution. And at that time, we have also discussed that one of the non-federal features of the Indian Constitution is that unlike the US, where the Senate, every state has an equal representation, in India, the Council of States have unequal representation of the states. So the second statement, which says all states have equal representation in the Rajya Sabha, is a wrong statement. So the correct answer is A, 1 only. So again, a very straightforward question. Consider the following statements regarding Rajya Sabha. The Constitution has fixed the term of office of the members of Rajya Sabha. 1/3 of its members retire every 2nd year. So we know that the Rajya Sabha is a permanent body and the members have a membership period of 6 years. The duration is not for the house, the duration is for the membership in the Rajya Sabha, which is 6 years, and 1/3 of them retire every, as much as possible, 1/3 of them retire every alternate years. So you know that the Constitution has the second statement. The moment you know the second statement is a right statement, again look at the options, you are eliminating 2 choices because these 2 choices don't have the second statement as a right statement. So it has again become a 50-50 question. The retiring members are eligible for re-election. and renomination. We know that there are members who again and again get elected to the Rajya Sabha. So you know the third statement is right. Then automatically you arrive at the right answer, which is 2 and 3 only, right? And the constitution has fixed the term of office for the members of Rajya Sabha is not a right statement, because it is not mentioned in the constitution, but it is mentioned in the Representation of People's Act 1951. So I am sorry, this is a question where you can still be stuck in 50-50, because you know that the second and third are right, but both option B and option D have 2 and 3 as right, and this is where just the elimination will not help you. You will also need to be aware of the provisions of the constitution and the Representation of People Act. So we have discussed that the 6-year membership period is not mentioned in the constitution, but the term of office being 6 years is mentioned in the Representation of People Act. So the correct answer is B, 2 and 3 only. Who among the following can incur a disqualification under the 10th schedule of the Constitution of India? It's a very straightforward question. You should be aware of the 10th schedule, which we have discussed in detail in the class. So if an independent elected member joins voluntary joins any political party, then he will be disqualified. The other things have errors. You can look at the answer key and you will be able to appreciate it. Consider the following statements. The salaries and allowances of the Speaker of Lok Sabha and the Chairman of Rajya Sabha are determined by Parliament. That is a very straightforward statement. It is the Parliament which decides on all salaries of members of the House and also of the Speaker and the Chairman. So the first statement is right, but the second statement is not right, because we have discussed specifically, highlighting it, that the Speaker, unlike the other members, does not immediately vacate his office, because he is the officer of Lok Sabha. Just like the chairman or the vice president is the officer of Rajya Sabha, the Speaker is the presiding officer of the Lok Sabha. And so there are administrative matters which needs to be taken care of even when the Lok Sabha is dissolved. So the Speaker does not vacate the office immediately, but he vacates it immediately before the first sitting of the next Lok Sabha. So the second statement is wrong. So the correct answer is A, 1 only. Regarding the election of Speaker, consider the following statement. The Speaker is elected by the Lok Sabha from amongst its members, and he shall resign from his party immediately after election. So the first statement is wrong, because the 10th schedule exception provides that the Speaker may choose to resign. And if he chooses to resign, he will not be subject to disqualification. But it is not compulsory, unlike in England, where the Speaker definitely resigns from his party. In India, that is not a compulsion. So the first statement is wrong. And the second statement is again a straightforward statement, a correct statement. Then membership of the House is something, as we have discussed in the class, it is applicable only for removal of officers of Parliament and officers of state legislature. So it is only the Speaker, Deputy Speaker, Chairman, Deputy Chairman, be it of Parliament or be it of the state legislature, who can be removed by majority of then membership of the House. So Speaker is definitely an officer of Parliament, Speaker of Lok Sabha. So the second statement is correct. So the option is B, 2 only. Which of the following statement is correct regarding the voting power of the Speaker? So we know the Speaker, as per the procedure, does not vote under normal circumstances in a normal bill or in a normal question. He votes only in the case of equality of votes. So the first statement is wrong. The second statement is just the contradictory statement to that. If there is a resolution seeking his removal, we know that he cannot preside over that meeting. If he cannot preside over that meeting, automatically he does not exercise the casting vote. So the second statement is also wrong. The third statement is the right statement. The Speaker, he cannot preside over the meeting, but he can vote in the first instance as a member. The chairman cannot do that of the Rajya Sabha because he is not a member of the house, whereas the speaker, being the member of the house, will vote in the first instance as a member for in a resolution which is for his removal. So the correct answer is C. Consider the following statements. The speaker is the final interpreter of the constitution within the house. The speaker's decision of certifying a bill as a money bill is subject to judicial review. So this is something which is also linked to current affairs. There is an Aadhaar Act which has been declared as constitutional by the Supreme Court. But what was one of the questions before the Supreme Court in that matter? Whether the speaker's decision to certify a bill as a money bill is subject to judicial review or not. The Supreme Court held that yes, it is subject to judicial review. It's a different matter that 4 judges said that it is fine that it has been passed as a money bill. Only 1 judge has said that no, it is wrong that it has been passed as a money bill. But unanimously all the 5 judges said that this is also subject to judicial review. So the second statement is a right statement. And speaker appoints the chairman of all parliamentary committees of the Lok Sabha. That's also a right statement. So the answer is 1, 2 and 3. Consider the following statements. The pro tem speaker is appointed by the president. Motion for removal of speaker of Lok Sabha can be considered and discussed only when it has the support of at least 75 members. But what is the most important thing in this question which many of you might have missed? Which of the following statements is incorrect? UPSC usually either puts it in italics, sometimes it puts it in italics and bold or sometimes it just gives it in bold, but definitely it should capture your eye. Oh, pro tem speaker is appointed by the president. Yes, that's a right statement. So you go and mark A, which is one only, as the right answer, then you are mistaken, your answer is wrong, because the question is not asking you for the correct statement, the question is asking you for the incorrect statement. And we have seen that the speaker removal requires an effective majority, which is majority of then members of the house, but there is only requirement that it should be given at least 14 days notice, but there is no number of members required. Please remember, the only 2 provisions which require a certain number of members to sign the resolution even before it is introduced is for president's removal and for removal of a Supreme Court judge or any other authority like High Court judge, CAG, CEC, who can be removed only like a Supreme Court judge. So these are the only 2 areas which require a minimum number of people to even introduce a resolution, not for removal of speaker, deputy speaker, chairman or deputy chairman. So the second statement is incorrect. So the answer is B, 2 only. Consider the following statement. Deputy speaker is nominated by the speaker. It's a wrong statement. You know that both the speaker and the deputy speaker are elected by the members of the Lok Sabha or the Legislative Assembly. So the moment you know the first statement is wrong, you have made it into a 50-50 question. So you know that the choice is only between B or D. But we know that whenever the speaker is either vacant or absent, immediately it is the deputy speaker who will perform the functions of the speaker. So the correct answer is B, 2 only, right. So look out for these elimination techniques, look out for statements which you know for sure is either right or wrong. Then based on that, you can definitely reduce it into a 50-50 question. In some cases where there are 3 statements and you know that one statement is correct or one statement is wrong, and there may be only one option which will fit into that category, then by just identifying one right or wrong statement, you will arrive even at the final answer. So that is something which you should always have in mind while attempting your questions. Which one of the following statement is correct? A member of scheduled caste and scheduled tribe is debarred from contesting in a general seat? No. It is only a member of non-scheduled caste or non-scheduled tribe who is debarred from contesting in the reserved constituencies which is reserved for the scheduled caste or scheduled tribe respectively. So it is not the other way around. So the first statement is incorrect. The 87th Amendment Act for revised delimitation, we have seen delimitation act has happened based on 51 census, 61 census, 71 census and 2001 census. But this it talks about 2011 11 census. So this statement is also wrong. SC/ST candidates are elected only by SC/ST population. So we have reserved constituencies, but we don't have a special electorate. We have a general electorate for all the constituencies. So the third statement is also wrong. The fourth statement is correct. The reservation for scheduled caste and scheduled tribes is based on their proportion of their population to the total population. And this is based on the 2001 census as of now. And after the first census after 2026, it may undergo a change. So the correct answer is D, which is the correct statement. Identify the correct statement from the following statement. In the first past the post system, the winning candidate must secure an absolute majority of votes. No, you should just get a simple majority of the votes. There is no requirement for you to get an absolute majority of the total electorate. Out of the votes polled, you just require a simple majority. First past the post system is also called as the plurality system. This is the right statement. But even if you are not very sure about this statement, I would have discussed it very briefly in the class. There are two types of system. First past the post system, which is also called as plurality system. The other is called a proportional representation system. So if you had missed it and you are confused, try and see whether you are able to eliminate the other statements. Then automatically you will arrive at the right answer. Proportional representation system is not followed in India for any election. We have seen the president gets elected by an election through proportional representation. We know the vice president gets elected through proportional representation by means of a single transferable vote. We know the Rajya Sabha members are elected like that. So you know that C is also incorrect. So you know that A is incorrect. You know that C is incorrect. Territorial constituencies primarily is provided by the first past the post system, because we know that Lok Sabha has territorial constituencies, whereas Rajya Sabha does not have territorial constituencies. Lok Sabha only is through first past the post system, Rajya Sabha is through proportional representation. So the statement D, which says that proportional representation system provides for territorial representation, is also a wrong statement. So you can arrive at the right answer based on your knowledge about the rest of the three statements and eliminating them. So even though you may not be sure whether first past the post system is indeed called as the plurality system, but you know that the other three statements are wrong. So automatically the correct answer is B, right? So that's the correct answer. Consider the following statements about delimitation commission. Delimitation commission is neither a constitutional body nor a statutory body. We have discussed briefly when we discussed the allocation of seats to the Lok Sabha and also the Legislative Assembly, that it is done by a commission called Delimitation Commission, which is based on an act of the Parliament. We have also said that there have been 4 delimitation commissions which have been set under 4 different acts of the Parliament, right? So the first statement is obviously wrong. The orders issued by Delimitation Commission cannot be challenged in any court. Yes, that's a right statement. So the correct answer is B, 2 only. Consider the following statements regarding the powers of the Speaker. Speaker decides the question of disqualification in the Lok Sabha on account of defection. 10th schedule, it is the Speaker or the Chairman, as the case may be, who decides whether a member is subject to disqualification or not. So the first statement is obviously right, but decision of the Speaker cannot be challenged in a court. We have just seen recent example also of 18 MLAs disqualified in the State Legislative Assembly by the Speaker. It was challenged in the High Court and the High Court finally gave a verdict that disqualification is valid. But it can be challenged in a court. So it cannot be challenged in a court of law is a wrong statement. So the correct statement is A, 1 only. The Electoral College of the President consists of, again, here is an example of a question where by just knowing that one statement is wrong, you would have arrived at the answer. All the members of both the houses of Parliament, we know that the President is elected only by elected members, not by all members, which includes the nominated members. So the first statement is, the first statement is wrong. The moment you know the first statement is wrong, you have the correct answer in front of you. So you don't even have to read the second and third statement. I just keep repeating it because you can be so confident about it, but please do read it once and satisfy yourself, yes, that is correct, but you don't have to worry even if you are slightly confused, because you know for sure the first statement is wrong, then the answer can only be C. which is 2 and 3. So, the president is elected by elected members of the parliament and elected members of the state legislative assemblies, right. So, the next question, with reference to the office of the Indian president, consider the following statement. The president can be removed from office by a process of impeachment for violation of the constitution. That's a correct statement. The impeachment charges can be initiated by the lower house of the parliament only. So, again, you may be confused with the statements, but the moment you know the first statement is correct and the second statement is wrong, because you know that the president can be impeached by an absolute majority in both the houses, but it can be introduced in either of the houses. It requires the resolution which is to be introduced should be supported by at least 1/4 of the total membership of the house in either of the houses, and 14 days notice should be given, and then it should be passed by 2/3 of the total membership of the house. So, that is the procedure. But if you know that the president can be impeached for violation of the constitution and you know that it can be introduced in either of the houses, you have arrived at the answer. You do not even have to bother about the third statement, because you know the first statement is right. So, the option is between you know the option could be A, B, C or D, but you know the second statement is wrong. So, this option gets eliminated, this option gets eliminated, and you know that it has to be introduced by 1/4 of the members, not by 100 members. It has to be supported by, should be signed by 1/4 of the members. So, you know that this statement is also wrong. So, the correct answer is A, 1 only. The Union Executive of India consists of President, Vice President, Council of Ministers and Attorney General, right. So, the choice is actually between A and D. You know the President, you know the Vice President, you know the Council of Ministers. They are the people who constitute the executive, but the Attorney General is also the legal advisor. So, one other way to simply remember it is Attorney General is under Article 76 of the Constitution. The Union Executive is between Article 52 and Article 78. So, anyone who comes between Article 52 and Article 78 is automatically part of the executive. So, the correct answer is D, President, Vice President, Council of Ministers and Attorney General of India. Consider the following statements. This is a straightforward question from a previous year paper. We have already discussed it. The President is the one who allocates business and who prepares the rules and regulations, and all the executive actions are taken out in the name of the President and not the Prime Minister. So, the first statement is correct, the second statement is wrong. It is a straightforward question. A cabinet minister can be removed by the President on his own discretion, with the consent of the Speaker, on the advice of the Prime Minister, on the advice of the judiciary. So, here you know judiciary is not involved in appointing and removing ministers. So, option D is eliminated. You know that the Speaker is a member of the legislature. So, he has got no role to play in appointing and removing executive, which is the Council of Ministers. So, option B is also wrong. So, now whether this is a discretionary power of the President? No, because what does the Constitution say? The Prime Minister shall be appointed by the President and all other ministers shall be appointed by the President based on the advice of the Prime Minister. So, while the ministers serve during the pleasure of the President, he does not exercise his discretion, he goes as per the advice of the Prime Minister. So, the correct answer is option C. Consider the following. Censure motion should state the reason for its adoption. No conference motion need not state the reason for its adoption. So, both the statements are right. We have discussed it as part of the legislative control. So, it is a straightforward question. Which of the following statements related to the governor are correct? He appoints the members of the subordinate judiciary. We have discussed it in our judiciary class that the Supreme Court and the High Court, the judges are appointed by the President of India. It is a unitary feature of our constitution. Whereas, for the subordinate courts in the states, the judges are appointed by the governor based on consultation with the High Court which has jurisdiction over those courts. So option, the first statement is right. He acts as a chancellor of all the universities within the respective states. So here is the catch. The governor does not act as chancellor of all the universities. He acts as chancellor of all the state universities, which means the universities which are run by the government, there he acts as the chancellor, not for private universities in the state. So the second statement is wrong. The moment you know these two statements, you have arrived at the right answer, because the option is only one. The third statement is wrong, because president and the governor cannot even entertain a court martial order. It is only the president who can exercise the pardoning power for any decision of the court martial. So governor does not enjoy that power. So the third statement is wrong. So the correct answer is C, one only. Indian president has the power of absolute veto with respect to which of the following bills? We have discussed this in our class. So whenever a bill has been passed by both the houses but the cabinet has resigned, then the government itself is not in power anymore. So he can exercise an absolute veto and reject that bill. Or if it is a private member bill, because private member bills are bills which are introduced by members who are not ministers. So even in case both the houses pass it, if the Council of Ministers advise the president to reject it, he can reject it. So the correct answer is 1 and 4 only. Again, you know that a constitutional amendment bill has to be accepted by the president. There is nothing called as returning the bill of a constitutional amendment and all, because we have discussed that when we discussed Article 111, that constitutional amendment does not come under this article because it is separately considered under Article 368. So the moment you know that the third statement is wrong, you have automatically eliminated two choices. So please look out for such one statement which can immediately reduce it into a 50-50 question, because then the chances of you getting the right answer increases that much more. Even if you are confused about the other statements, you know for sure that the answer is only between these two. And if you have 20 questions like that where it is 50-50, still not able to make up your mind, probability says that you will get 50 right, 50 wrong. So net you will have only a positive score. So please look out for these elimination techniques whenever you are confused about the choices. The disputes relating to the election of president can be decided only by the Supreme Court. Both the president and the vice president can be decided only by the Supreme Court. It is a straightforward statement. Regarding the veto power, the Indian president enjoys which of the following? So we know that he enjoys absolute veto in some cases. We know that he enjoys suspensive veto under normal circumstances under Article 111. We know that under exceptional circumstances he may enjoy even pocket veto. But qualified veto, which requires 2/3 majority when the bill is returned by the president, is something which is there in the US but not in India. So the correct answer is 2, 3 and 4. And again, the moment you know that qualified veto is not there for the Indian president, you have arrived at the right answer. So this is just an example. I mean, in this question you may be very clear about the choices, but please look out for such questions where by just eliminating one statement you will arrive at the correct answer. So these things you should definitely keep in mind while answering your questions. So with regard to the pardoning power of the president, which of the statements given below are incorrect? The pardoning power of the president is an executive power. That is an executive power, because again, as I told you, anything which comes between Article 52 and 78 of the Constitution is relating to union executive. Pardoning power is under Article 72. So it is an executive power. It is not a judicial power. Don't get confused. It is an executive power of the president. The question again is which of it is incorrect. So you are not looking for the correct statement, you are looking for the incorrect statement. He can grant pardons to persons who have been sentenced for an offence against an union law. We have discussed that is the scope of the pardoning power of the president. The president can pardon a death sentence while a governor of state cannot. We have seen that as the distinction between the pardoning power of the president and the pardoning power of the governor. Two distinctions primarily. Only the president can pardon a death sentence, governor cannot pardon a death sentence, at best he can commute a death sentence, And the second distinction is only the president can deal with court martial, governor cannot deal with the decision of a court martial. So the third statement is also correct. President cannot pardon sentences inflicted by court martial is wrong. It is only the president who can either pardon or commute or give a reprieve, remission, whatever it is. Court martial, any decision, all the powers only the president can exercise. So the fourth statement is incorrect, and that is the correct answer. The resolution for removing the Vice President of India can be moved in. I mean, and when I say moved in, it actually means can be introduced in. Introduced in only the Rajya Sabha. So we have again specifically discussed this in the class. The distinction between removal of President and Vice President, of course the majorities are different, that is a separate matter. But President removal can be introduced in either of the houses. But Vice President removal, who is the chairman of Rajya Sabha, can be introduced only in the Rajya Sabha, and it should have an effective majority, which is majority of the then membership of the house in Rajya Sabha, and then it goes to the Lok Sabha, where it should again be agreed by the Lok Sabha by a simple majority. But it cannot be introduced in the Lok Sabha. It cannot be introduced in a joint sitting, right? So the correct answer is D, which is Rajya Sabha. Consider the following statements. In case of any delay in conducting the election of new president, Vice President acts as the president. No, Vice President acts as the president in the case of removal, resignation, death, or otherwise the president is removed from his office. Only then he acts as the president. If there is a delay in conducting the election to the office of president, then the existing president will continue till his successor enters his office. The same is the case with the Vice President also, right? So it is not, the first statement is not correct. When the Vice President acts as President or discharges the functions of the President, he shall not perform the duties of Chairman of Rajya Sabha. That is again straightforward from the Constitution. We have seen whenever the Vice President acts or performs the functions of the President, he will not act as the Chairman of Rajya Sabha. It will be the Deputy Chairman who will act as the Chairman of Rajya Sabha during that period. So the correct answer is B, 2 only. Right? Which one of the following statement is not correct? Again, look out for these italicized words. It is in italics and it is also bold, and that is how UPSC also asks. Sometimes it may not be in italics, but it will definitely be bold, and sometimes it may be just in italics, but it will definitely be different from the normal other words printed. So UPSC is facilitating you to pick that word. And despite that, if you make an error, if you do not read the word not and you mark the correct statement out of this, then that is a criminal mistake, right? It is not, it is something which cannot be pardoned at all, right? Like how a president can pardon some even death penalties, but this mistake, it is definitely not pardonable. So please be careful while looking out for such words. So which of the statement is not correct? Again, we have seen this first statement is correct. The Vice President of India can be removed by a simple majority of votes. No, we know that for removal of officers of Parliament, which is the Speaker, Deputy Speaker, Chairman, Deputy Chairman, the majority that is required is effective majority, which is majority of then membership of the House. So automatically, you don't even have to read the next two sentences. You know that this statement is incorrect. It is not it's not a question where few options are given and a combination is given. It's one out of the 4 statements. So the second statement is the correct answer. It's the correct answer. It's the incorrect statement, and that is why it is the correct answer, right? Which of the following statements are correct? The Prime Minister shall be appointed by the President and other ministers shall be appointed by the President on the advice of the Prime Minister, straight from Article 75. Resignation of Prime Minister automatically dissolves the Council of Ministers. We have discussed this. He is the head of the Council of Ministers. So the moment the head goes, everything falls. And we have even cited the example when the Chief Minister died, or in Tamil Nadu 2 years back, or when in the Bihar the Chief Minister resigned and formed a new Council of Ministers. The entire council vacates and the new council is again sworn in. So the second statement is also right. The Constitution has provided the procedure for selection appointment of the Prime Minister. It does not say anything like that. It only says the Prime Minister shall be appointed by the President. Look at the first statement. That gives the answer. The first statement only says the Prime Minister shall be appointed by the President. There is no special procedure and selection and appointment process which is given. So automatically, by just looking at the first statement, you know the third statement is wrong. So the correct answer is 1 and 2 only. Consider the following statements about the role of Prime Minister in relation to Council of Ministers. The President shall make rules for more convenient transaction of the business of Government of India and for the allocation amongst the ministers of the said business. This is a straightforward statement from the Constitution. The President can appoint only those persons as ministers who are recommended by the Prime Minister. Look at the previous question. The first statement gives you the answer. The Prime Minister is appointed by the President and other ministers are appointed by the President based on the advice of the Prime Minister. So it is not his discretion. He has to go as per the recommendation of the Prime Minister. So the correct answer is both 1 and 2. Parliamentary democracy ensures the accountability of Council of Ministers to which of the following? So in India, they are accountable to the Lok Sabha only, not to both houses of Parliament. Article 75(3) says the Council of Ministers shall be collectively responsible to the House of People, which is the Lok Sabha. So the correct answer is C. Consider the following statements with reference to Chief Minister of the state. He shall prove majority in the Legislative Assembly of the state before being appointed as Chief Minister. This is wrong. Only in case of a hung assembly where no party has a majority, even there, it is the Chief Minister who is appointed first and then the Governor usually gives time to prove the majority, right. You need to have a Council of Ministers to actually go and seek confidence vote in the House. So without the Council of Ministers, there is no point in having a confidence motion, and Council of Ministers cannot be without the Chief Minister. So it is not before being appointed, it is after being appointed that the Council of Ministers including the Chief Minister may be asked to prove their majority in case no party has a majority. But if it is a straightforward case where one party has a majority in the House, then the Governor will not ask the Chief Minister to prove his majority because they know that they have the majority, right. But in any case, even if there is a hung assembly, it is not before the appointment, because only after the appointment the Council of Ministers itself is formed and they only go and seek the majority vote in the House. So the first statement is wrong. He can be appointed as Chief Minister even if he is not a member of the state legislature. That is applicable to any minister including the Chief Minister or any minister including the Prime Minister in the Union. You have 6 months time to become a member of one of the houses of the state legislature or the Union Parliament. So the second statement is correct. Council of Ministers consists of Cabinet Ministers we know, Ministers of State we know, Deputy Ministers we know. So automatically you know the choice is between B and D, but Parliamentary Secretaries, we have briefly discussed this when we discussed about the disqualification, right, by the President or the Governor if they hold an office of profit, and I had cited you the example of Delhi where there were members who have been appointed as Parliamentary Secretaries. So Parliamentary Secretaries also form part of the Council of Ministers as per the rules of Lok Sabha. So they will also be included, right, as part of the Council of Ministers. So the correct answer is 1, 2, 3 and 4, right. The Governor has discretionary powers in which of the following cases? Reservation of a bill passed by the state legislature for consideration of the President, recommendation for the imposition of the President's rule in the state. The moment you know the first two statements are correct, you have arrived at the right answer. Again, you know the first and the second statement is right, then the only choice which has both the statement as right is D. Understand? Exercising his functions as the administrator of an adjoining union territory. We have discussed this briefly when we discussed about the discretionary powers of the Governor, right, and also in some scheduled areas and special powers under the various states of Nagaland, Mizoram and all that. But you may be slightly confused whether does he exercise his discretionary power or does he act as per the advice of the Council of Ministers. It's common sense, because the Council of Ministers are only for the state, not for the adjoining union territory. But I am only saying, take this as an example. There may be some questions where the third statement may be slightly confusing and you are not sure whether the third statement is right or not. But you don't have to get confused at all, because you know that the first and second statement is right. The moment you know it, it's not even a 50-50, it's a straightforward answer in this case. Because the only choice which has both 1 and 2 as correct statements is option D, right. So, the correct answer is option D, 1, 2 and 3. Which of these constitutional functionaries are appointed by the governor? State Election Commissioner is appointed by the governor. Advocate General of a state is appointed by the governor. Chairman and member of State Public Service Commission is also appointed by the governor. So, all of the above is correct. The constitution lays down which of the following conditions for appointment of a governor? The governor should not belong to the state to which he is appointed. I have specifically said that this is not a constitutional requirement. This is the convention which has been followed, and it has been reiterated by the Sarkaria Commission, and that has again continued to be followed even now. So, it is not mentioned in the constitution. So, the first statement is wrong. The moment you know the first statement is wrong, you have automatically eliminated 2 choices. It becomes a 50-50 question. So, the choice is between B and D. The governor's appointment must be made after consulting the chief minister of the state. We had jokingly said in the class, if that is the case, governor, no opposition rule states under any government will get a governor, because the state government and the central government will not have consensus on a candidate. It is something which is recommended by the Sarkaria Commission, but which is not followed. So, the moment you know it was recommended by the Sarkaria Commission, you know that it is not there in the constitution. So, that makes the option D also as wrong. So, the correct answer is B, 3 only, because a governor should not be a member of either House of Parliament or House of the State Legislature, right. So, that is a constitutional requirement. So, the correct answer is B, 3 only. Consider the following statements. The constitution does not lay down any grounds upon which a governor may be removed by the president. Yes, it does not say that. Governor is consulted while appointing the judges of the concerned state high court. He is consulted, because the constitution originally said the president shall consult the Chief Justice of India, Chief Justice of the concerned high court and the governor of the state. Now, under the collegium process, who initiates the vacancies for appointment of judges of the high court? The Chief Justice of the concerned high court. After consulting the senior judges in the high court, but after that, where does he send that recommendation? He sends it to the governor of the state, which is the state government, and then they forward it to the union government, and from there it ultimately comes to the collegium of the Supreme Court, which is the final authority which will recommend the name to the president. So, but the governor is there in the loop. So, the question is, he is consulted. He is not the final authority, but he is indeed consulted even through this collegium process. So, the correct answer is both 1 and 2. The ordinance making power of the governor is coextensive with the legislative power of the state legislature. So, what does this mean? The governor can promulgate an ordinance, of course, based on the advice of the Council of Ministers for any matter in the state list, right. So, or in the concurrent list also, because the state legislature has the power even for a concurrent list matter, as long as it does not violate any of the central law. So, the ordinance making power of the governor being coextensive with the legislative power of the state legislature means that it can be promulgated only on those subjects for which the state legislature can make laws. So, a governor cannot promulgate an ordinance for a matter in the union list, right. So, the correct answer is B. Who among the following can be the electors in the elections to the legislative council of the states? Members of municipalities. So, this is a straightforward, if you recollect the chart that we have discussed in the class. Members of municipalities select elect one third of the people, teachers elect 1/12, graduates elect 1/12, MLAs elect 1/3, and 1/6 gets nominated by governor. So, the MPs from the state do not have a role to play in the election of legislative council members. So, 5 is not correct, the rest of the 4 is correct. So, the correct answer is 1, 2, 3 and 4. The privileges that belong to each house of the state legislature collectively are, it can make rules to regulate its own procedure and conduct its business and to adjudicate upon such matters. So, we have seen what is the privilege of the house collectively. It is the same for parliament as well as for state legislature. So, the first is a collective privilege of the house, and the courts are prohibited into inquiring into the proceedings of a house or its committees. So, the correct answer is both 1 and 2. Which of the following statements related to the comparison of Rajya Sabha and Legislative Council is correct? Again, you can ensure that you are eliminating all the wrong answers, then you will arrive at the correct answer. Legislative Assembly have the power to override the Legislative Council, but can Lok Sabha override the Rajya Sabha? It can override the Rajya Sabha only in case of a money bill, not in case of ordinary bills. So, the second statement you know is incorrect. Members of Legislative Councils can't vote in presidential election, whereas all Rajya Sabha members of Legislative Council can't vote in presidential election. That part of the statement is correct, whereas all members of Rajya Sabha can. That part of the statement is wrong. So, please be careful while reading the options. You will have to be very, very vigilant. All members of Rajya Sabha do not vote for presidential election. It is only the elected members of Rajya Sabha who vote for presidential election. So, while this part of the statement is correct, this part of the statement is wrong. So, overall the statement cannot be marked as correct. And once you know that two statements are wrong, all of the above automatically is not a correct statement. So, the correct answer is A. Both the Rajya Sabha and Legislative Council of the states are permanent bodies and are not subject to dissolution. Legislative Council may be abolished, but the moment it is created, it continues. There is no concept of dissolution of Legislative Council, just like there is no concept of dissolution of Rajya Sabha. Only the Lok Sabha and the Legislative Assembly are subject to dissolution once every 5 years or earlier by the President or the Governor based on the advice of the Council of Ministers. When the Legislative Assembly disagrees to a bill originated in the Legislative Council and passed by the latter, a deadlock is reached. The Governor is bound to reserve the bill for consideration of the President. It is only when both the houses pass a bill and send it to the Governor, he can recommend it, he can reserve it for President's assent in his discretion. So, first statement is wrong. A joint sitting of both the houses is called. We have specifically discussed that the concept of joint sitting is applicable only to the Union Parliament. There is no such thing for the state legislature. So, the second statement is wrong. The Legislative Assembly sends the bill to the Legislative Council for its reconsideration. It is the other way around. When a Legislative Assembly passes a bill, the Legislative Council may send it with its recommendations or amendments. But if the Legislative Council passes a bill and the Legislative Assembly rejects it, the bill becomes dead and no further action is taken. So, the correct answer is D. Consider the following statement regarding the ordinance making power of the President. The ordinance making power is not a discretionary power. That is true. He acts based on the advice of the Council of Ministers. That is also true. Constitution can be amended by proclamation of an ordinance. So, you know that ordinance cannot amend the Constitution. The moment you know that statement 4 is wrong, you have eliminated two choices. And statement 1 or 3 are interrelated. You know the first statement is right because it is not a discretionary power, and it is based on the advice of the Council of Ministers that the President promulgates an ordinance. So, you arrive at the right answer, which is 1, 2 and 3. But please look at this. In every question where there are 3 statements or 4 statements, even in 2 statement questions where you know that one of the statement is definitely right, just with one statement you can reduce it into a 50-50 question. So, please be careful about that, and you know one more statement, invariably you will arrive at the right answer. So, please apart from your knowledge, please also judiciously use these elimination techniques. Consider the following statements. Constitutionally, the President has the right to be informed of all important matters and deliberations of the Council of Ministers. That is a right statement. It is not necessary for the Prime Minister to information all the information that the President may call for. No, that is a wrong statement. So, 78, Article 78 says that the Prime Minister will inform the President about all important decisions being taken by the Council of Ministers, and he shall furnish whatever information the President may call for. So, the first statement is right, the second statement is wrong. So, the answer is A, 1 only. So, that is the correct answer for this question. Identify the Incorrect statement, again incorrect. Be careful about this. All the other statements are correct. Appropriation of monies out of Consolidated Fund of India is Article 110(1)(d), that has been changed to Public Account of India here. So, this is the incorrect statement. It is the correct answer because it is the incorrect statement. So, this is just a slight modification of the 2018 prelims question. So, appropriation of monies out of Consolidated Fund of India, whereas here it is given as Public Account of India. So, that is a wrong statement. Consider the following statement: the Parliament has the power of discussing and enacting changes to the Constitution. That is correct. It is only the Parliament which can amend the Constitution. State legislatures cannot do it. The constituent powers of both the houses is the same in this respect. We have seen under the salient features itself that the Constitution has to be amended by 2/3 majority in both the houses. So, they have equal power with respect to constitutional amendment. A constitutional amendment bill seeking changes in the federal provisions of the Constitution has to be passed by more than 50% of the members present and voting in the Parliament. So, we know that 2/3 majority is required for most of the cases. Only for few cases it is majority of the members present and voting, which are not considered to be amendment to the Constitution. In fact, the federal provisions require not just 2/3 majority in both the houses. After that, it should be approved by, or resolution should be passed approving that amendment by majority of the states. So, but here it is said as majority of the members present and voting in the house. So, that is a wrong statement. So, the correct statement is, correct answer is option B, which is 1 and 2 only. Which of the following constitutes the electoral college for the election of the Vice President, elected and nominated members of Parliament? That is all, because state legislative assemblies do not play a part. Elected members of Parliament only is applicable for President, not for Vice President. So, the correct answer is option A, which is elected and nominated members of the Parliament. They vote in presidential election, sorry, Vice Presidential election. Which of the following is the expenditure charged upon the Consolidated Fund of India? So, emoluments and allowances of President, salaries and allowances of Chairman and members of Union Public Service Commission, any sum required to satisfy a judgment or a decree. So, 1, 3 and 4 is correct. Salaries and allowances of judges of High Court is not charged on the Consolidated Fund of India, it is charged on the Consolidated Fund of the respective states. But please remember, the pension of High Court judges after they retire is charged on the Consolidated Fund of India. But here it says salaries and allowances of the High Court judges only. So, you should not get confused between with all of the above, because it is only salaries and allowances of the judges of the High Court which is charged on the Consolidated Fund of those respective states. So, the correct answer is option A, 1, 3 and 4. And the final question with respect to polity: what is the procedure required to be followed for abolition of an existing legislative council in the state? This is a straightforward question from the Constitution. There has to be a resolution which should be passed by the legislative assembly of the state with a special majority, majority of the total membership of the house, which is not less than 2/3 of members present and voting. And after that, the Parliament has to pass a simple law. So, if you look at the other options, one option says only Rajya Sabha has to pass a law, the other option says only Lok Sabha has to pass a law. No, that law has to be passed by both the houses. So, option A and C is wrong. State legislative assembly must pass a resolution to that effect by majority of the members present and voting, which is a simple majority, is also wrong. The state legislative assembly should pass a resolution through special majority, and then it goes to the Parliament, which has to pass a law in both the houses by a simple majority. So, the correct answer for this question is option B. So, that concludes the polity related questions. So, I hope you found this discussion useful. The purpose of this discussion, as I told you again, is not to teach constitution through this, because that is what I am doing in the class. So, the purpose of this is to let you know how you should ensure that you are very cautious in reading the options, very cautious while reading the question itself, not missing the correct or the incorrect, that is one thing. Secondly, ensure that you read all the options thoroughly. Thirdly, by just knowing one statement, whether it is right or wrong, invariably you will arrive at a 50-50 kind of situation. And then you can, if you know one more statement, whether it is right or wrong, then invariably you arrive at the right answer. So please be, please look out for such statements so that you can immediately quickly eliminate 2 options, or in some cases even 3 options, but at least 2 options, and then arrive at the final answer based on going through the rest of the options. And always look for linkages. Even in the UPSC paper, which is a full syllabus paper which includes polity, history, geography, current affairs, environment, everything, even there could be some linkages, which means what? If you know the answer for one question, or the statement given in one question could be the answer for some other question. So always look for those linkages, right? So, and most importantly, please definitely attempt the answer question paper for the full 2 hours that is allotted to you. Now, I have discussed about the constitution, the polity part of it, but for current affairs and map related questions, those are straightforward questions. The current affairs are from the month of June. The map related questions were on the specific geographies which were given to you. So there have been questions which have been asked based on that. They are straightforward questions. When I say straightforward questions, it is either from current affairs or a map related question. The explanation, the answer key which will be circulated to you will have detailed explanation even for those questions. Go through them. If you still have any doubt, you can always approach the respective faculty for clarification. So thanks for watching, and please keep all this in mind for all the future tests. Good luck.